All right, welcome. Hello, everyone. Welcome to our Tuesday talk for January 2022. Can't believe we're already in the new year. Last year and the year before seemed to have flown by us, which is fine by us, right? For those of you who are new visiting us today, welcome. My name is Jeff Luna. I'm the admissions coordinator for independent and assisted living here at Holly Hall Retirement Community. Again, thank you so much for joining us today. We have a couple of people here in person. Our residents, we've had to cancel the in-person gathering for this month. Unfortunately, we had a little bit of a COVID outbreak here, so we wanted to keep everybody safe. So we've canceled this in person. I'm hoping that we can have the in-person starting again in February for the next Tuesday talk. But we will definitely get that information out to you to let you know if you would like to join us in person. Today, our Tuesday talk topic is essential documents for estate planning. And we have a special guest, Miss Theresa Clarke, who is an attorney with Wright, Abshire attorneys. So she will be able to, she'll talk about essential documents.
So when we talk about simple versus complex, when we talk about tax planning, so we say here that simple wills have typically no tax planning, and also no trusts.
And when we talk about tax planning in an estate planning context, we're really generally talking about the federal estate tax. Some call it an inheritance tax because it's the tax that whoever inherits from you is going to pay upon your death. So currently, however, there's an exemption. So you can have so much in your estate and it's completely exempted from this estate or this inheritance tax. Right now in 2022, that's $12.06 million. So I don't know about you. I don't have that kind of money. My estate would not be taxable if I died today or tomorrow. And for a couple, it's double that. So that means if your estate is worth less than that amount in this year, then there's no tax reporting, no tax due, no estate tax. It's completely exempt. The estate tax has been in the news a lot, especially lately in the last year, because the estate tax exemption amount has changed a lot over the last several years and even decades. It's fluctuated, but typically it's been increasing over the last couple of decades, where it is now at just above 12 million. Now, currently it's been in the news, but there currently aren't any proposals in Congress to change it that have gone forward. However, this current tax regime is expected to, or it will, unless Congress does something to change it, it's going to what they call sunset. That's a term that's used in Congress and with state legislatures. It will just sunset, meaning it's going to revert back to what it was before it was doubled. In other words, it's going to go back to 5 million, but that's indexed for inflation. So it's really going to be more like $6 million, that exemption amount. That's going to happen January 1, 2026, unless Congress does something to change it. Only time will tell. I don't have a crystal ball. I have no idea what's going to happen, but that's what that is. Tax plan wills or trusts typically include a type of marital trust or a family trust, often called a bypass trust. Simple wills also would leave everything that you own upon your passing to people outright. So it could be your spouse, it could be your children, it could be nieces or nephews, it could be a charitable organization. But the reason we call that simple is it's because it's going outright to those people or those organizations instead of in trust. So for example, if you have a disabled adult disabled child, and you leave everything to that person outright, just know, and we'll talk about this more in a little bit, but that's the result of some uninformed planning. Okay, so why don't people want to have their estate plans done? I do have a couple of people in the room. If you want to shout out any reasons that you think people don't want to make their estate plans, I'm all ears. Otherwise, I will just keep going. I'll give you a minute.
If they don't want to see what they do or don't have.
So they don't, okay, yeah. So people might not want to make wills because it's kind of a fear, right? They don't want to see what they don't know or what they don't have. Procrastination is a big one. Simple. You know, I think many of us, I shouldn't say all of us, but many of us procrastinate. And that is certainly one reason. Another reason is they don't think their estate is large enough. They think, oh, it's going to be simple. Everything is going to go to my kids. I don't have a very large estate. I don't need a will. Another reason is, well, they just don't even want to worry about it. I'm just going to let my heirs or my children or my nieces and nephews, I'm just going to let them worry about it because I'm going to be gone. I don't care. They might think it costs too much. That's common, right? They might think it costs too much to have a will or estate plan. And really, this is something that I hear a lot, is it might just find it uncomfortable, you know, it's thinking about death, thinking about when you pass away. That's an uncomfortable feeling for most of us. And a lot of people do feel like if I start talking about it and thinking about it and planning for it, that's going to somehow trigger, you know, the end. And last, one reason is they don't know an attorney, or they don't want to know an attorney. Right? Okay, so those are some reasons that people don't have estate plans or you know, procrastinate. Who needs a will? Well, I would argue that everyone needs a will, whether you're single, whether you're married, whether you have children, whether you don't have children, whether you have a blended family. That is a definite. You definitely want a will if you have a blended family. If you have a child or other family member with special needs, that they might need special treatment in your estate plan, that's a definite. So I want to talk a little bit about community property and separate property. Texas is a community property state. And if you're married, your property is either considered to be community property or it's considered to be separate property. Community property is anything that's been acquired during the marriage, and that includes your income. So you earn an income, that becomes community property, and it's shared between you and your spouse. Separate property is anything that was acquired before the marriage or acquired as a gift or an inheritance, for example, from a parent or a sibling. Even if that's after you've been married. So that's considered your separate property. The trick is that once you start mingling that separate property with your community property, it's really hard to separate that out later. So the presumption is under the law that is community property. And this makes a big difference when it comes to who is going to inherit your estate upon your death. If you're married and you have children and all of the children are part of that marriage, upon your death, then your the community property will go to your spouse. Okay, that's what happens with it. If the person who's passed away, though, is married but has children outside of that marriage, maybe from a first marriage, that changes everything. That means all of that person's community property goes to the children. Now, of course, the surviving spouse keeps his or her half of that community property, but half of it goes to the children. That's if there are children who are outside of the marriage, maybe from a previous marriage. And remember, this is if you pass away without a will, because these are the laws, this is the law that governs what happens if you should pass away without a will. Separate property, if you have any separate property, like cash, investments, personal effects, things of that nature. And the same scenario where there are children who were from a different marriage. 2/3 of that will go to the children, and 1/3 of that separate property goes to the surviving spouse. If it's real estate, so for example, that we see this a lot in Texas, people inherit minerals from their family members, from their parents. Sometimes it's from a distant cousin. You don't even know you have it, but there's this mineral interest. If it's real estate, and that includes minerals in Texas, and you pass away without a will, and there are children outside of that marriage, the spouse you have when you pass away, again, the children will take 2/3 of that outright, and the surviving spouse gets a life estate in 1/3. So not even a real full benefit of that. And then upon this surviving spouse's death, that then goes to the kids. So the kids of the person who's passed away will receive all of that. Now, if you are not married and you die without a will, then your property passes to your lineal descendants, your children, your grandchildren, your great-grandchildren. If you have no children, then if you have parents, it'll go to your parents, otherwise to your siblings or their children, so your nieces and nephews, and then their children, great nieces, grandnieces and nephews, and down the line that way. And if you should pass away without children or lineal descendants, or siblings who are living, or nieces or nephews who are living, then you kind of go up to the next generation and go out from there. So in other words, that would be if you have any aunts and uncles, cousins, children, first cousins once removed, second cousins, third cousins, you get the idea. It goes to some distant relatives. That's if you pass away without having a will, and you don't have any, and you're not married when you pass away. So I wanted to go through all that in kind of some detail to just let you know why it's important for people to have a will, or at least some reasons. Texas, I would say a bit about writing your own will. Texas does allow handwritten wills, but there are specific requirements. These are called holographic wills. And so these are allowed in Texas. It can be admitted to probate. That will can be probated, but I would say do this at your own risk, because inevitably people think about maybe some specific items that they want to go to specific people, and that's why they're writing a will. But then that's all that passes under that will, and the rest of it will go just like I described under the Texas laws of descent and distribution. And also I want to point out here that there are a lot of ways that property can pass to others that have nothing to do with the will, that pass outside of a will. So if you think about retirement accounts, investment accounts, life insurance policies, stocks, a lot of other financial assets that you might have, those pass by way of, or transfer by way of contract when you pass away. In these cases, what that is usually, part of that is usually a beneficiary designation. So if you have a life insurance policy and you have a beneficiary designation, say, to my 3 children in equal shares, then that's who that life insurance policy will go to, right? It will not pass under the terms of your will. It will not require probate. But the caution there is that if any of the, first of all, if you have a primary beneficiary named and no contingent, but the primary beneficiary perhaps has passed away before you, and we haven't gotten around to changing our beneficiary designations, that happens quite frequently, then what that does is it will pass under your will. It'll pull that back into your estate because there's really no beneficiary designation, unless there's a default policy that the company might have. Okay. I want to talk a little bit about making changes. You know, how often should you make changes? If you already have a will, and we get this question a lot, how often should I change it? What should I do? If you have a very large estate, you know, several million, then you're probably keeping up with changes in tax law that might affect you. And if that's the case, then keeping in contact with your attorney is a very good idea. Otherwise, you should consider changing a will when there's been a major life event, such as a marriage, a divorce, definitely. A child who becomes incapacitated or maybe passes away before you do, or a spouse who becomes incapacitated. These are all reasons to consider making a change to your will if you have one. But even sometimes with major life events, except for divorce, your current will might be okay. Right? So for example, if your will that you have leaves everything to your children, and if and it states that if one of your children, if any of your children should pass away before you, then it goes to their children, would be your lineal descendants, then you're probably, going to be okay and wouldn't need to make a change. But always you should ask, if you have a lawyer, an estate planning lawyer, you should ask, is it time to make a change or should I make a change? If you do want to make a change to your will, you should contact the attorney who drafted it for you. Wills should not be tampered with. Staples should not be removed. You shouldn't write on your wills. You shouldn't remove any pages, certainly, because that brings everything into question, when the court is trying to decide, is this a valid document or not? Okay. So just a couple of let's see. Yeah, okay. So again, if you have no will and you pass away, your property will be disposed of under those laws that I just went over a little bit ago. In addition, assuming your estate needs probating, so if there are assets that need to be transferred and distributed to your heirs, then the only way that a judge can determine how your estate is distributed if you don't have a will is to make a judgment about who the heirs are and appoint somebody to be an administrator. This is almost, well, I would say it's always more costly to do it this way. So it can be done, of course, if you don't have a will, but it's more costly. The judge is going to appoint somebody, perhaps even to be a dependent administrator, meaning they'd have to get court permission for everything they do. And a will can include an appointment of an independent executor so that they can proceed with their duties under the will independently without seeking permission from the court. You should always name at least 2 alternate executors in your will, because that also can be very costly and time consuming if your executor that you've named doesn't want to serve, or they've passed away or become incapacitated. For people with minor children or adult children who are under a guardianship, you can appoint guardians in your will. Okay, so that's an important reason to have a will. You can also include trusts that will be established on your death. These are those testamentary trusts I was talking about before. For family members who are living with disabilities and or special needs, or who face other types of challenges, a trust for their benefit is often a very good idea. Okay, and I'm just going to talk about a few trust terms, just basic terms that are part of trusts. The settlor or grantor, sometimes also called the trustor, is the person who makes the trust. They're the one who establishes the trust. The trustee is the person or the entity, because it might be a corporation, for example, that administers the trust. The beneficiary, that's the person or persons or entities like charities that benefit from the trust. So they're going to be the people or the organizations that will receive your property or a part of it, whatever part you have put into your will. There are some different types of trusts. We have self-settled trusts, third-party trusts, third-party settled trusts. Those are types of trusts that are usually discussed in the context of special needs planning or supplemental care trusts, special needs trusts, sometimes called supplemental care or supplemental needs trusts, for people who might be receiving public benefits, or even if they're not receiving public benefits, like social supplemental security income or Medicaid, they might have special needs that would make it so that a trust would be a good idea for them. Self-settled is a trust, though, that you might create for yourself with your own funds for your benefit. Third party is simply a trust that somebody else creates for another person. So you could create, for example, a third party special needs trust for a grandchild. Okay, that's one example. Okay. And I talked about first party and third party. Testamentary trust, I also talked about that at the very beginning. It's part of a will, so it's part of your last will and testament, and now we just say will. Actually change that in the Texas statute. We don't even really use that phrase last will and testament anymore, although many people still do. This is a trust that's going to take effect not until you pass away. So that trust it exists on paper, but it doesn't really take effect until you pass away. And an inter vivos trust, I also talked about this at the beginning. This is also a living trust, called a living trust, takes effect during the lifetime of the settlor or the grantor. A lot of times people have a revocable trust for management purposes. One benefit of an inter vivos or living trust is that it can avoid probate. I put a little asterisk next to this slide because it only is going to avoid probate if, while you're living, all of your assets are either put into that trust or otherwise directed to the trust upon your death. So that's important. And it names a fiduciary, a trustee. Just like your will, you name an executor. Your trust, you name a trustee. Okay. Now I'm going to switch gears and talk about advance directives. These are documents that are often more important sometimes than your will or your trust. Not that the will or trust is not important, but these advance directives are very important. Yes, we're ahead. Go to 12 or 13. Keep going. Okay, good. Thank you. Okay, we're caught up on the slides now. All right, good. Let's see. All right. Like I said, these are documents that are very, very important. You have a power of attorney for financial affairs or a financial power of attorney. You might hear me saying that. Medical power of attorney, directive to physicians, some often known as a living will. Declaration of guardian in the event the need arises, in the event of incapacity. And then there's a HIPAA authorization, which that HIPAA document, I'm sure many of us have signed those before in hospitals or doctor's offices. The federal law requires one medical facility to take another medical facility's HIPAA document and treat it as their own, but often they don't do that. So we always prepare a HIPAA document authorization. That stands for Health Insurance and Portability Accountability Act. I think of it as the privacy document, and I'll talk about that in a minute. So the advantages of advance directives, it's really part of any complete estate plan. It prepares you for possible incapacity by providing specific instructions, naming agents who can act for you on your behalf if and when you're unable to do so. It helps to ensure your wishes are carried out, and you'll see there are some very strong powers that agents can be given. It can prevent costly guardianship proceedings in most cases. And really, these documents just make things easier on family members. So these are very important. So the first one I'm going to talk about is the durable power of attorney. This for property, and I mentioned I sometimes call this the financial power of attorney. This is where a document where you're naming an agent to step into your shoes to handle your financial affairs on your behalf. Durable means that it remains effective even when you, the principal is the person who signs the document, and then the agent is the person they name as the person they want to help them out. So durable means that it remains effective even after you become incapacitated. Texas has a statutory form, it's in statute, and it's called a statutory durable power of attorney. If you have a power of attorney and it's not from the statute or it's different, you may want to look at it. It may not be a durable power of attorney, which means that if you become incapacitated and you're unable to make decisions, handle your financial affairs because of that incapacity, it could mean that actually that power of attorney ended, so that terminates. So what we prepare, and I think what most attorneys prepare, most estate planning attorneys prepare, are durable powers of attorney that follow the statute. But you can also have a power of attorney that's very limited for a specific purpose. If there's some real property to sell and you want to give someone the ability to sell that property just for that purpose, then of course that can be done as well. Even with the statutory durable power of attorney, there are many choices to make on the form, and one of those choices is that you can decide that it takes effect immediately. That's the default. It takes effect immediately when you sign it, or it can take effect only when you become incapacitated. That's called springing. It springs to that later time when you might be become incapacitated. Now, some say, why make it why not make it, or why make it effective sooner than you need it? I have full capacity now. I can handle all of my own affairs. I just want to make it springing and only take effect when I become incapacitated. However, the caution is that by doing so, the practical effect of that is that your agent that you've named in your power of attorney is going to have to find a physician, your physician or a physician, to certify in writing that you are incapacitated. This could take some time. This could potentially take a lot of time. And so what's happened in that scenario is that you're almost guaranteeing a headache for your agent. What I want to say, really, the point is you're naming someone you trust. You want to name someone off the bat that you trust, whether that's an adult, one of your children, a very close friend, maybe even a grandchild that you really trust to handle your financial affairs for you if you're incapacitated. And if you trust that person while you have capacity to make your own decisions, then to me, you ought to make sure you trust them after you become incapacitated, because that's when they're really going to be stepping into your shoes and when they're going to be needed. There are other choices to make in the power of attorney, which is allowing your agent to gift on your behalf, and that there are so many reasons to that's a good idea, not just giving gifts to people willy-nilly, but you might need to have a trust for your benefit. There might be a need to transfer property. And sometimes without a gifting power, your agent won't be able to do those things on your behalf. So it's a very powerful tool. You can do a lot with a power of attorney. Now, medical power of attorney is of course different. This is about you're appointing an agent to make healthcare decisions for you when you can't make them yourself. Okay, so this is always springing. It's always ineffective until you become unable to make decisions for yourself. Okay. Until this point, even if you have a medical power of attorney, you're the one in control, right? Even if you have signed a medical power of attorney, you've appointed your daughter and then your, maybe other children after that as your agent or your alternate agents. They don't have any decision-making authority until you have no capacity to make those decisions for yourself. You can always revoke this document. You might name the same people that you've named as your executor under your will or your agent under your financial power of attorney, but maybe not. Maybe you have one child, your daughter might be better able to handle your financial affairs, and your son who might be better able to make healthcare decisions for you. It really just depends on your family. And those don't necessarily have to be in the same order as they are, under your will or your trust, okay? And just one last note on medical powers of attorney is Texas does not allow co-agents. So 2 agents or more than one agent. So you have to decide who's going to be your primary agent under your medical power of attorney and then your alternates after that. And you can name as many alternates as you want, but they'll be in order there. The directive to physicians is the next document I want to talk about. This is also called the living will. And in simple terms, a directive to physicians and family members, that's what our form is called, is a statement of your wishes with regard to life support. That's really in simplest terms, that's what it is. It's your end of life wishes. It's effective only when 3 factors are present. 1, you have either a terminal or irreversible condition, which I'll get to in a second. 2, you cannot communicate your wishes. So as long as you can communicate, this has no effect, okay? So 3, you have no reasonable chance of recovery to a meaningful life. In other words, you need life support, life-sustaining treatment to stay alive, okay? So it only is effective when these 3 factors. You have a terminal or irreversible condition, you cannot communicate your wishes, and you need life support or life-sustaining treatment to stay alive. Terminal condition is essentially defined as, by the way, I am a lawyer, not a doctor. So really these are conversations that you need to have with your physician, your medical care professional about what this means for you, okay? But definitions, with terminal condition, no matter what the doctors do, there's virtually no chance that you're going to survive more than 6 months. Of course, nobody has a crystal ball. Nobody knows when we're going to die, not even our doctors. But that's the definition. So it's essentially the same test that determines whether somebody needs hospice care. An irreversible condition is one where there's no cure, like many cancers, right? Many cancers. You may or likely will die from this condition eventually, but doctors have the ability to sustain you and keep you going. You don't need that life support, at least at the time that you have this irreversible condition. Many of us remember the case of Theresa A out of Florida. She had an irreversible condition. So that's the importance of this document, is to let your family members know what it is that you want, so that there aren't any, or it reduces the possibility of fighting among your loved ones if you're in this situation. I want to point out also that this is different from a do not resuscitate or DNR order, which is a document signed by a physician. Essentially states that if your heart stops or your pulmonary function ceases, then medical professionals should not try to revive you. That's different. That's a completely different document that lawyers do not prepare. So again, I just want to reiterate how important it is to discuss this with family members. Even if you have it in writing, this is one of those things that really most people don't want to talk about, but it's really important to let your family members know what it is that you want. I'm going to move on next to the HIPAA document. This is simply the document that tells medical professionals with whom they can discuss and provide your private medical information, whether that's one person or whether it's several people. So it's a document where you name one or more people, so you can, here, doctor, this is my HIPAA authorization. I'm authorizing you to talk to these people, give them my private medical information, which can be very important. Okay. The next document is the Declaration of Guardian in the event of incapacity or before the need arises. You may remember that earlier I said that one of the reasons to have estate planning documents is to avoid a costly guardianship proceeding. And I will say that even with, well, let me put it this way. When you have a power of attorney for financial affairs and a medical power of attorney, you will probably not ever need to have a guardianship, because those documents are going to allow your agents to do what it is that needs to be done. So a guardian of the person is who is responsible for caring for the person's well-being. A guardian of the estate is the person who's responsible for managing the financial affairs. Now, I said usually if you have those other documents, then you won't need a guardianship. But unfortunately, sometimes it's needed. If you've got children who are fighting amongst each other and they disagree about what you need and the type of care you need and what to do with your money, then somebody, either one of those children or another, third party might need to actually file for a guardianship to sort of take control and get things back to where they should be. You could also have your agent under your financial power of attorney doing things that they shouldn't be doing, maybe even breaching their duty to you, breaching fiduciary duty. And so someone's going to need to have a guardianship to take control away from that person. And sometimes also it's needed because there's the person is refusing to leave home, or they're a danger to themselves, and a guardianship might be needed in that case as well. The last document that I'm going to talk about is the appointment of agent to control the disposition of remains. Doesn't that sound fun? And it is what it sounds like. So many people, I would say a lot of people, leave these matters to their family members to handle. Maybe they've talked about it, like, I want to be cremated or I want to be buried. They've probably had maybe at least that conversation, but a lot of times that hasn't happened. If you have the calm and the resolve to do so, it's best to prepare in advance and consider doing this in advance for yourself. So probably a lot of you listening have, or perhaps have, a prepaid funeral contract where you already have not only made all the decisions for exactly what you want to happen, but you've paid for it too, or you've designated some life insurance policy to pay for that when you pass away. So that's one aspect. The other thing, and that's not what this slide is about, is this other document, which you can also name an agent who was going to be the one responsible to take care of you when you pass away, right? This might be especially important if cremation is what you want, because if there's no pre-need cremation or funeral plan or contract, and if there's no agent who's been appointed by you to control that situation, then all the family members have to agree that you can be cremated. If they don't, then the funeral home will do nothing until they get a signed agreement by all of, if it's all your children, for example, or until they receive a court order. So that's no fun for anybody, especially at that time. So that's also can be an important document, or at least something to think about as you're planning. I hope that this session has been interesting to you and helpful to you. And I wish you a great day and a great week. Thank you so much.
I do have a question.
Yes,
Theresa.
yes.
I hope everybody can hear me. This might be kind of the Terry Shivo thing. I've been seeing a few articles and reports about people like in South America doing assisted suicide. You know, I know that's more you're supposed to be able to communicate that. So you really wouldn't bring a lawyer in for any of that, right?
You wouldn't, yeah. I mean, that's not something that's allowed here. And so, you know, assisted suicide is something that you wouldn't bring, right, to the lawyer.
Because I guess with the Dr. Kevorkian thing back in the day and all that, it was very hush in the hotel room, whatever. So
right. No, that's a good question. I mean, this is also though a very good, you raise a good point and bring up something important, which is that really what everyone should do is talk to their loved ones, their closest loved ones, about what they want and their wishes. That's right.
Let me see if we have anything in the chat. I don't think we do. All right. Well, thank you so much, Theresa. It was an interesting topic. I know a lot of people don't like to talk about things like that, as Theresa was saying, but being in this industry, I do see it a lot. All right, is that better? Oh, here we go. Thank you, Theresa. Very interesting. You know, it is conversations that we don't like to have, but it's obviously something conversation we do need to have with our loved ones. Being in this industry, I do see a lot of these documents that Theresa was talking about. So it's very important to have those documents prepared and at least let your, like you said, make your wishes known, because you know, there will be some infighting, unfortunately, and that's something that families don't want to do at that time of, you know, when you pass away. You want your family to celebrate your life instead of fighting for your life or fighting your life in court. So again, thank you so much for the very informative conversation. Theresa has dropped off some packets for people. I can either mail a copy to you, mail a packet to you. What else we will do is we will scan these the documents in here and put them on our website for you to print off. So if you would like to get a hard copy in the mail, I'd be happy to mail one to you. You could either email me at jluna, L-U-N-A, at hollyhall.org. That's HOLLYHALL.org. And I will get that over to you. So the next Tuesday talk will be on February 15th. It's going to be on chocolate, a world unto itself. So we're celebrating Valentine's Day. Everybody loves Valentine's Day. Description about the topic. After Columbus brought cacao beans back to Europe from the New World, chocolate spread from being a fashionable drink and a sign of wealth to an important commodity in developing countries. Learn about chocolate's significant influence on the arts. So I hope everybody loves chocolate. I know that's a weakness of mine sometimes. So hopefully we will be able to see you in person for next month's discussion, and we may have some chocolate for you. So thank you so much. Thank you, Akeem, for today, for the audio. We apologize for the difficulties we were having at the beginning. I think we may have figured it out. Technology clearly is not our friend, but we made it through. So stay safe, everyone. Happy New Year. I know it's already the third week, and I hope everyone's New Year is off to a good start, and we hope to see everybody in person next month. Thank you so much. Have a good rest of the day.